Hi, I'm Mairead McErlean, a senior litigator at Debenhams Ottaway Solicitors in St Albans. Welcome to our Companies in Crisis series. A few Q&As today for directors who are concerned about the company's position given the current pandemic. We've been asked the question, what duties do I as a director owe, and do those duties change if the company becomes insolvent? Broadly speaking, there are three categories of duties: statutory duties, common law duties, and duties which are found in the company's own constitution. The statutory duties are found in the Companies Act. There are 7 codified duties. I'm not going to go through each of those individually now, but broadly speaking, they can be summarised as acting in the company's best interests, doing things to promote the success of the company, and ensuring that you don't do things that compromise that or put you personally in a better position at the expense of the company. There are further statutory duties set out in other legislation. These are generally where the company has a duty, but that duty also extends to a personal liability for the directors. For example, certain health and safety legislation, environmental legislation, and anti-corruption legislation. There is a general common law duty of confidentiality which all directors owe to the company which employs them. This duty is to keep the company's confidential information confidential at all times, and that duty continues after a director leaves that company. And finally, there may be some additional duties set out in the company's Articles of Association. In addition to additional duties, there may also be limitations on the director's usual powers. So it's very important to consider what is set out in the company's own Articles of Association. A director has to remember that the director's duties are owed to the company. They're not owed to the shareholders. They're not owed to the creditors. There's no direct relationship between the director and the shareholders and the director and the creditors. However, the company's duty to the shareholders and the company's duty to its creditors change in the event of an insolvency. Generally speaking, a company has a duty to its shareholders. However, when that company becomes insolvent, that duty changes and the obligation is owed to its creditors. From a director's perspective, it's important to first of all know what your duties are, and second of all, know what limitations have been placed on your powers. Finally, you need to consider both when making any decisions. Don't let your personal interests or obligations that you owe to other companies cloud your judgment when making a decision. Equally as importantly, don't let external pressure, such as pressure from shareholders or a particular shareholder, or creditors or a particular creditor, compromise your decision-making process. Keep in mind your duties and act in accordance with them. In the event that a company does become insolvent, an insolvency practitioner will step in. And one of the things which the insolvency practitioner can do is look at your conduct prior to the insolvency. In certain situations where directors' duties have been breached, the insolvency practitioner can take action against you personally. It's therefore important to keep this in mind at all times, and if you do have any questions or queries, take advice